Hello everyone, welcome back to FDVN's program on Administrative Procedures Decoding, and the topic for today is work permits for foreigners. Have you been wondering in which case you must apply for a work permit for a foreigner? What are the required documents to apply for a work permit? How to carry out this procedure? What are the forms of sanction for violation related to work permits? Stay with FDVN's Today program on Administrative Procedures Decoding, and we will help you avoid the potential risks when applying for work permits for foreigners, saving your time, effort, and money. Based on this information, you can find the best solution for your businesses in the initial step of recruiting foreign workers. First of all, what are work permits? A work permit is a document that allows a foreigner to work in Vietnam in accordance with the law. The work permit must clearly state information about the employee, including full name, passport number, date of birth, nationality, the name and address of the organization they work for, their position at work. And the work permit is an important document for foreign workers to apply for a 2-year temporary residence card in Vietnam. Decree number 152/2020/NDCP provides the form of a work permit, which is form number 12/PLI, within 5 working days after receiving a duly completed application. The Ministry of Labor, War Invalids and Social Affairs, or the Department of Labor, War Invalids and Social Affairs of province where the foreign worker is expected to work shall issue a work permit to the foreign worker, using form number 12/PLI Appendix 1 hereto appended. If the application is rejected, a written explanation is required. Number 2, validity period of a work permit. According to Article 10 of Decree number 152/2020/NDCP, the validity period of a work permit shall coincide with any of the period or duration below but not exceeding 2 years. 1. Validity period of the employment contract to be signed. 2. Duration of the foreign worker's assignment in Vietnam. 3. Duration of the contract or agreement concluded between Vietnamese and foreign partners. 4. Duration of the service contract or agreement concluded between Vietnamese and foreign partners. 5. Duration determined in the document issued by the service provider to send the foreign worker to Vietnam to negotiate the service provision. 6. Validity period in the operation license of the agency, organization, or enterprise. 7. Duration determined in the document issued by the service provider to send the foreign worker to Vietnam to establish a commercial presence. 8. Duration stated in a document proving the foreign worker's eligibility to participate in the operation of a foreign company that has established its commercial presence in Vietnam. And 9. Duration stated in the acceptance of employment of foreign worker unless a report on demand for foreign workers as specified in Point B Clause 1 Article 4 hereof is not required. Number 3, cases where foreign workers are exempt from work permits and the procedures to request for certification of exemption from work permits. Not all foreign workers are required to apply for work permits. Some entities are exempt from work permits and therefore, enterprises need note this information to reduce unnecessary procedures. According to Article 7 of Decree number 152/2020/NDCP, work permit exemption is applied for a worker who 1. Is the manager of a representative office, project, or the person in charge of the operation of an international organizations or a foreign non-governmental organization in Vietnam. 2. Enters Vietnam for a period of less than 0.3 months to do marketing of a service. 3. Enters Vietnam for a period of less than 0.3 months to resolve complicated technical or technological issue which affects or threatens to affect business operation and cannot be resolved by Vietnamese experts or any other foreign experts currently in Vietnam. 4. Is a foreign lawyer who has been granted a lawyer's practicing certificate in Vietnam in accordance with the law on lawyers. 5. In one of the cases specified in an international treaty to which the Socialist Republic of Vietnam is a signatory. 6. Gets married with a Vietnamese citizen and wishes to reside in Vietnam. 7. He or she is the owner or capital contributor of a limited liability company with a capital contribution value of at least 3 billion dong. 8. He or she is the chairperson or a member of the board of directors of a joint stock company with a capital contribution value of at least 3 billion dong. 9. He or she is an intra-company transferee within 11 sectors in the schedule of commitments in services between Vietnam and WTO, including business services, communication services, construction services, distribution services, educational services, environmental services, financial services, health services, tourism services, recreational and cultural services, and transport services. 10. He or she enters Vietnam to provide professional and engineering consulting services, or perform other tasks intended for research, formulation, appraisal, supervision, evaluation, management and execution of programs and projects using official development assistance in accordance with regulations or agreement in international treaties on ODA signed between the competent authorities of Vietnam and foreign countries. 11. He or she is granted a Communication and Journalism Practicing Certificate in Vietnam by the Ministry of Foreign Affairs as per the law. 12. He or she is sent by a foreign competent authority or organization to Vietnam to teach and study at an international school under management of a foreign diplomatic mission or the United Nations, or of a facility established under an agreement to which Vietnam is a signatory. 13. He or she is a volunteer as specified in Clause 2 Article 3 of this decree. 14. He or she enters Vietnam to hold the position of a manager, executive, expert or technical worker for a period of work of less than 30 days and up to 3 times a year. 15. He or she enters Vietnam to implement an international agreement to which a central or provincial authority is a signatory as per the law. 16. He or she is a student studying at a foreign school or training institution which has a probation agreement with an agency, organization or enterprise in Vietnam, or a probationer or apprentice on a Vietnam seagoing ship. 17. He or she is a relative of a member of foreign representative body in Vietnam as specified in Point L Clause 1 Article 2 hereof. 18. He or she obtains an official passport to work for a regulatory agency, political organization, or socio-political organization. 19. He or she takes charge of establishing a commercial presence. 20. He or she is certified by the Ministry of Education and Training as a foreign worker entering Vietnam for teaching and research purpose. In order for the authorities to know that the employee is exempt from a work permit, the employer must carry out the procedures for requesting for certification of exemption from work permit. For any of the circumstances in Clauses 4, 6 and 8 Article 154 of the Labor Code and Clauses 1, 2, 8 and 11 Article 7 of this decree, the employer is not required to apply for the certification of exemption, but it must report to the Ministry of Labor, War Invalids and Social Affairs or the Department of Labor. War Invalids and Social Affairs of province where the foreign worker is expected to work, at least 3 days before such foreign worker starts to work in Vietnam, on the following information: full name, age, nationality, passport number, name of employer, starting date and completion date. Accordingly, in order to request for certification of exemption from work permit, the employer shall send requests to the Ministry of Labor, Invalids and Social Affairs or the Department of Labor, Invalids and Social Affairs of province where the foreign worker is expected to work, confirming that the foreign worker is exempt from a work permit at least 10 days in advance from the date the foreign worker starts working. Required documents are provided in Clause 3, Article 8 of Decree No. 152/2020/NDCP. Within 5 working days after receiving a duly completed application, the Ministry of Labor, War Invalids and Social Affairs or the Department of Labor, War Invalids and Social Affairs shall issue a certification of exemption from work permit, using Form Number 10/PLI Appendix 1 hereto appended. If the application is rejected, a written explanation is required. Number 4. Procedures for applying for work permits for foreigners. Step 1. Determination of demand for foreign workers. At least 30 days before the date on which foreign workers are expected to be employed, the employer shall determine the demand for foreign workers for every job position for which Vietnamese workers are underqualified and send a corresponding report to the Ministry of Labor, War Invalids and Social Affairs or the People's Committee of Province or Central Affiliated City, hereinafter referred to as province, where the foreign workers are expected to work. Using Form Number 01/PLI Appendix 1 hereto appended. If the foreign worker falls under any case of Clause 3, 4 and 5 Article 154 of the Labor Code and Clauses 1, 2, 8, 9, 10, 11, 12 and 13 Article 7 of this decree, the employer is not required to determine the demand for foreign workers. the Ministry of Labor, War Invalids and Social Affairs or the People's Committee of Province shall issue a document specifying accepted job positions and non-accepted job positions, using Form Number 03/PLI Appendix 1 hereto appended within 10 working days after receiving the foregoing report on demand for foreign workers or report on change thereof. Step 2. Apply for work permits. At least 15 working days before the day on which a foreign worker starts to work, the employers or Vietnamese agencies, organizations or enterprises or foreign organizations, enterprises operating in Vietnam where the foreigners work shall submit an application for work permits to the Ministry of Labor, War Invalids and Social Affairs or the Department of Labor, War Invalids and Social Affairs of the province where he or she is expected to work, within 5 working days after receiving a duly completed application. The Ministry of Labor, War Invalids and Social Affairs or the Department of Labor, War Invalids and Social Affairs of province where the foreign worker is expected to work shall issue a work permit to the foreign worker, using Form Number 12/PLI Appendix 1 hereto appended. If the application is rejected, a written explanation is required for a foreign worker specified in Point A Clause 1 Article 2 hereof. After the foreign worker is issued with a work permit, the employer and the foreign worker must sign a written employment contract as per Vietnam's labor law before the date on which the foreign worker is expected to work. The employer shall send that employment contract to the competent authority that issued that work permit. The employment contract is the original or a certified true copy. Number 5. The relation between work permits, temporary residence cards, notarized translation, and consular legalization. These documents and procedures are strongly related to each other. For instance, before applying for a work permit, it is mandatory to apply for a visa when the foreigner enters Vietnam, maybe a DN visa. While applying for a work permit, it is required that foreign language documents such as judicial records issued by foreign competent authorities, degrees, professional certificates, etc. be translated, consular legalized, then the translation must be notarized. This is an inseparable service chain. When notarizing documents, documents in foreign languages must be consular legalized before its translation can be notarized. For foreign workers' passports, it must be translated and then notarized. When applying for a temporary residence card for foreign workers, a work permit is required to apply for a temporary residence card for cases that require work permits. Number 6. Sanctions for violating provisions on work permits. Regarding violations of work permits, Decree No. 28/2020/NDCP provides sanctions for administrative violations in the field of labor, social insurance, and sending Vietnamese workers to work overseas under the contract as follows. Employers can be fined from 1 million VND to 3 million VND for failing to send copies of the signed labor contracts to work permit issuing bodies in case foreign workers work under labor contracts. Employers can be fined from 5 million VND to 10 million VND per a worker, but not exceeding 75 million VND for hiring foreign workers in a way in breach of information shown in their work permits or written confirmations of their exemption from work permit requirements. Foreign workers in Vietnam can be fined from 15 million VND to 25 million VND for working without work permits or without written confirmations of exemption from work permit requirements as required by law, and get deported. Foreign workers in Vietnam can be fined from 15 million VND to 25 million VND for using work permits or written confirmations of their exemption from work permit requirements that have already become null and void, and get deported. Employers can be fined from 30 million VND to 75 million VND for hiring foreign workers to work in Vietnam without work permits or written confirmations of their exemption from work permit requirements, or hiring foreign workers holding expired work permits or written confirmations of exemption from work permit requirements already null or void. And that's the end of this video. We hope the information that FDVN has presented above is useful to you. In the next program, FDNV will continue to bring you new information related to the law. To support the program, please click like button and share FDVN's channel to people around you. Thank you and see you next time.